Hello and welcome to an episode that talks about Intellectual Property Act. I'm Swati Singh, a media professional for the last 12 years, specialized in mass communication. I have worked as a journalist with the Hindustan Times, Indian Express, Career Launches, etc., and have also taught print and electronic media in various universities and colleges, including the Delhi University. Today, we shall be discussing Intellectual Property Act, which is a great catalyst in preserving original work of various artists, writers, poets, inventors, etc. This act is largely helpful in ensuring safety of information of great value and provides the creator a way to manage his or her professional work. Related security. Now let's start by discussing the objectives of this episode. The objectives of this lesson are to understand the meaning of Intellectual Property Act, to learn about the Patent Act, to learn about the Copyright Act, to understand about the Trademark Act, to learn the classification of intellectual property, to learn about the characteristics of intellectual property, to understand about the requirements of inventions, to understand what are the various invention types, to learn about the need of patent and patentability, to learn about inventions that do not correspond to novelty. Let us start by defining intellectual property. According to the World Intellectual Property Organization, WIPO, intellectual property refers to creations of the mind, such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. Intellectual property is protected by law, for example, by patents, copyrights and trademarks, which enable people to earn recognition or get financial benefit from what they invent or create. By striking the right balance between the interest of the innovators and the wider public interest, further, the intellectual property system aims to foster an environment in which creativity and innovation can flourish. Now let's talk about the Patent Act. The Patent Act was created in the year 1970. A patent is a form of an intellectual property. It consists of a set of exclusive rights granted by a sovereign state to an inventor or their assignee for a limited period of time in exchange for the public disclosure of the invention. An invention is a solution to a specific technological problem and may be a product or a process. Now let's understand the procedure for granting patents. The requirements placed on the patentee and the extent of the exclusive rights vary widely between countries, according to national laws and international agreements. Typically, however, a patent application must include one or more claims that define the invention. These claims must meet relevant patentability requirements, such as novelty and non-obviousness. The exclusive rights granted to a patentee in most countries is the right to prevent others from making, using or selling or distributing the patented invention without the permission. Under the World Trade Organization WTO agreement on trade-related aspects of intellectual property, rights patents should be available in WTO member states for any invention in all fields of technology, and the term of protection available should be a minimum of 20 years. Nevertheless, there are variations on what is patentable subject matter from country to country. Now let's talk about the Copyright Act. The Copyright Act came into being in 1957. It is a legal concept enacted by most governments, giving the creator of an original work exclusive right to it. usually for a limited period of time. Generally, it is the right to copy, but also gives the copyright holder the right to be credited for the work, to determine who may adapt the work to other forms, who may perform the work, who may financially benefit from the work, and other related rights. It is a form of intellectual property, like the patent, the trademark, and the trade secret, applicable to any expressible form of an idea or information that is substantive and discrete. Copyright initially was conceived as a way for government to restrict printing. The contemporary intent of copyright is to prove the creation of new words by giving authors control of and profit from them. Copyright initially was conceived as a way for government to restrict printing. The contemporary intent of copyright is to promote the creation of new works by giving authors control of and profit from them. Copyrights are said to be territorial, which means that they do not extend beyond the territory of a specific state, unless the state is a party to an international agreement. Today, however, this is less relevant, since most countries are parties to at least one such agreement. While many aspects of national copyright laws have been standardized through international copyright agreements, copyright laws of most countries have some unique features. Typically, the duration of copyright is the whole life of the creator, plus 50 to 100 years from the creator's death, or a finite period for anonymous or corporate creations. Some jurisdictions have required formalities to establish copyright, but most recognize copyright in any completed work without formal registrations. Generally, copyright is enforced as a civil matter, though some jurisdictions do apply criminal sanctions too. Most jurisdictions recognize copyright limitations, allowing fair exceptions to the creator's exclusivity of copyright and giving users certain rights. The development of digital media and computer network technologies have prompted reinterpretation of these exceptions, introduced new difficulties in enforcing copyright, and inspired additional challenges to copyright law's philosophical basis. Simultaneously, businesses with great economic dependence upon copyright have advocated the extension and expansion of their intellectual property rights and sought additional legal and technological enforcement. Now, let's come to the Trademark Act. Established in the year 1999, the Trademark Act, with the globalization of trade, brand names, trade names, marks, etc., have attained immense value that require uniform minimum standards of protection and efficient procedures for the enforcement, as were recognized under the TRIPS. In view of the same, extensive review and consequential amendment of the old Indian Trade and Merchandise Marks Act 1958 was carried out and the new Trademarks Act of 1999 was enacted. The said Act of 1999, with subsequent amendments, conform to the TRIPS and is in accordance with the international systems and practices. The Trademark Act provides inter alia for registration of service marks, filing of multi-class applications, increasing the term of registration of a trademark to 10 years, as well as recognition of the concept of well-known marks, etc. The Indian judiciary has been proactive in protection of trademarks, and it has extended the protection under the trademarks now to domain names, as demonstrated in landmark cases of Tata Sons Limited versus Manu Kusori and ORS in 2001, and Yahoo Inc. versus Akash Arora 1999. Being a common law country, follow not only the confided law but also common law principles, and such provides for infringement as well as passing off actions against the violation of trademarks. Section 135 of the Trademark Act recognizes both infringement as well as passing off actions, well-known trademarks, and trans-border reputation. India recognizes the concept of well-known trademark and the principle of trans-border reputation. A well-known trademark in relation to any goods or services means a mark that has become so to substantial segment of the public which uses such goods or receives such services such that the use of such a mark is relation to the other goods and services is likely to be taken as indicating a connection between the two marks. Trans-border reputation concept was recognized and discussed by the apex Indian court in the landmark case of N.R. Dongre versus Whirlpool in 1996. The trademark Whirlpool was held to have acquired reputation and goodwill in India. The mark Whirlpool was also held to have become associated in the minds of the public with Whirlpool Corporation on account of circulation of advertisements in the magazine despite no evidence of actual sale. Hence, the trademark Whirlpool was held to have acquired trans-border reputation which enjoys protection in India, irrespective of its actual users or registrations in India. Legal remedies against infringement or passing off under the Trademark Act, both civil and criminal remedies, are simultaneously available against infringement and passing off. Infringement of trademark is violation of the exclusive right granted to the registered proprietors of the trademark to use the same. A trademark is said to be infringed by a person who, not being a permitted user, uses an identical or similar, deceptively similar mark to registered trademark without the authorization of the registered proprietor of the trademark. However, it is pertinent to note that the Indian trademark law protects the vested rights of a prior user against a registered proprietor which is based on common law principles. Passing off is a common law tort used to enforce unregistered trademark rights. Passing off essentially occurs when the reputation in the trademark of a party A is misappropriated by a party B, such that the party B misrepresents as being the owner of the trademark or having some affiliation or nexus with party A, thereby damaging the goodwill of party A. For an action of passing off registration of a trademark is irrelevant. Registration of a trademark is not a prerequisite in order to sustain a civil or criminal action against violation of trademarks in India. In India, a combined civil action for the infringement of trademark and passing on can be initiated. Significantly, infringement of a trademark is cognizable offence and criminal proceedings can be initiated against the infringers. Such enforcement mechanisms are expected to boost the protection of marks in India and reduce infringement and contraventions of trademarks. Let us first understand the classification of intellectual property acts. To classify the above intellectual property and intellectual property acts, the three following points of views are generally utilized. The first one is classification by purpose of law. The classification can be made in terms of purpose of each intellectual property act. Industrial property laws can be classified into two groups according to their purposes. Industrial property law that aim to help industrial development such as the Patent Act, Utility Model Act, Design Act and Trademark Act, and the Copyright Act which aims to encourage cultural development. Classification by subject of protection. Secondly, the classification can also be made in terms of the subject of protection for each intellectual property act. Industrial property laws can be classified into two groups according to their purpose. Thirdly, laws on creation, to protect creations that are produced through creative activities by human beings, such as inventions, utility models, designs and works, and laws on marks to protect marks that indicate goods or services used in business activities by companies. Classification by protection method. Further, the classification of intellectual properties can be made in terms of the method to protect the intellectual property as well. Industrial property law can be classified into two groups according to their purposes. Law providing rights for right holders to protect intellectual property such as Patent Act, Utility Model Act, Design Act, Trademark Act and Copyright Act, and laws regarding the Act that directly regulate the Act of infringement to protect intellectual property, such as the Unfair Competition Prevention Act. Now let us learn about the characteristics of intellectual property rights. The intellectual property and intellectual property rights have four major characteristics in common. Firstly, they are intangible objects. The first characteristic is that intellectual property does not have any substance. In other words, it is an intangible object. To cite an example, it may be seen that music, which is sort of a work, is tangible when it is written as sheet music or recorded on a CD. But the music itself, such as the background music played in a coffee shop, is intangible. In parallel, this characteristic results in the fact that intellectual property can be utilized at the same time and in the same form by more than one person. For example, two people can listen to a piece of music together, while a dress cannot be worn by two people at the same time. In contrast to intellectual property, that is intangible object, an object having a substance such as a dress is called a tangible object. Exclusivity. The second characteristic of intellectual property right is that of exclusivity. This means that only the right holder can utilize the intellectual property concerned, and that the right holder is entitled to exclude others who utilize the said intellectual property without obtaining the right holder's permission. Intellectual property rights and ownership defined by the Civil Code have the common characteristics that the right holder can hold absolute control over his or her own property, thanks to its exclusivity. However, there is a significant difference between industrial property rights and copyright among intellectual property rights in terms of exclusivity. Industrial property rights, including patent rights, have the effect of absolute exclusive rights. For example, Mr. X and Mr. Y respectively completed the same invention of alpha, and Mr. X then obtained the patent A for this invention. In this case, even if Mr. Y has completed an invention of alpha by himself, he would be infringing the patent right of A and Mr. X when working on invention alpha. On the other hand, a copyright has the effect of relative exclusive rights. For example, Mr. X and Mr. Y have respectively drawn the same painting, beta. In this case, both Mr. X and Mr. Y obtained a copyright on painting B. Therefore, even if Mr. Y published a painting B which was drawn by himself, he would not infringe the copyright of B or of Mr. X. Time limitations. The third characteristic is that intellectual property has time limitations. For example, the term of a patent right is 20 years from the date of filing of the patent application, while the term of a trademark right is for 10 years from the registration date of its establishment. Although both intellectual property rights and ownership have exclusivity as mentioned above, intellectual property rights have time limitations contrary to the ownership. The fourth characteristic is that intellectual property is based on the principle of territoriality. That is the principle. It includes 2 points. First, the effect of Indian intellectual property right is limited to India. Therefore, such rights are effective only in the territory of India and do not have any effect in the other countries. This is why Indian patents may exclusively work their patented inventions in India, but not in the other countries. Secondly, the content of Indian intellectual property rights are defined by the Intellectual Property Acts of India, and it is therefore India's Patent Act, not foreign laws, that specifies issues such as which sorts the inventions may be patented in India and which effects may be granted to the patented rights. What are the requirements for inventions, we might ask? Well, inventions must meet all four of the requirements we will discuss. If you make a patent application for those that do not fulfill the requirement for an invention, you cannot obtain a patent right. The first one is we need to utilize the law of nature. First invention must utilize the law of nature. Laws of nature means rules that are found in the natural world through experiences. Law of nature include, for example, the law of conservation of energy and rule of thumb such as the fact that logs float in the water. Meanwhile, mathematical formulas or rules such as the calculation method or the area of a circle, artificial arrangements such as the rule of sports and games, or psychological rules including hypnosis are not included in the laws of nature. An invention must utilize such laws of nature. Therefore, those that do not utilize the laws of nature are not deemed an invention. For example, a law of nature itself, such as finding that logs float in water. Those that are against the laws of nature, such as perpetual motion machines, a machine deemed to be able to operate indefinitely, that is against the law of conservation of energy, and those that utilize rules other than the law of nature, such as subliminal advertising that utilizes psychological rules. Technical ideas. Secondly, the inventions must be technical idea. Technical here means specific measure to achieve an objective. For example, we are considering technical ideas and therefore not deemed to be invention, which are skill, expertise, know-how, and secret techniques. These can include as the pitching method of a folk ball, the simple presentation of information such as photograph of a landscape of Himalayas, simple aesthetic creations such as paintings and sculptures, and incomplete inventions that lack concreteness and are deemed to be whimsical. Thirdly, creations. The inventions must be creations. Creation here means those created by human beings. For example, if you have discovered a new type of acid producing bacteria that produce a chemical seasoning, this may not be deemed an invention since you have not created such a bacteria. Conversely, if you have invented a process of purifying a substance by using a new type of acid-producing bacteria, this may be deemed as invention because you have not simply discovered a kind of bacteria, but you have created a process of purifying a compound. Advanced and fourth, inventions need to be advanced. However, utility models protected by the Utility Model Act are not required to be advanced. In other words, these requirements serve to differentiate the Patent Act, which is a system to protect relatively advanced technology from the Utility Model Act in order to protect relatively simple technology. Now let's understand the invention types. Inventions can be classified into two major categories: the invention of a product and the invention of a process. The invention of a process can be further classified into two groups: the invention of a non-production process and the invention of a production process. Invention of a product. First, an invention of a product is an invention that can be produced and does not contain a time element in the elements constituting the invention. For example, a reversible garment having a sari pattern on the front and a dress pattern on the reverse is deemed as an invention of a product. Invention of a process. Next, an invention of a process is an invention that contains a time element, the sequential nature of a process, in the element constituting the invention. The invention of a process includes the invention of a non-production process and the invention of a production process. An invention of a non-production process is an invention of a process that does not produce any products. For example, an invention of process B for inspecting the sewing of reversible garment alpha is deemed as invention of a non-production process because using this process does not produce another reversible garment alpha. An invention of a production process, on the other hand, is an invention having three elements, namely starting material, process, and the product, and producing a product, resultant object by using such process. For example, an invention of process Y for producing reversible garment alpha is deemed as invention of a production process because using this process produces another reversible garment alpha. Requirements for patentability. To obtain patent rights in certain countries like Japan, inventions must meet all 6 of the following major requirements for patentability, in addition to requirements that must correspond to the definition of invention defined by the Patent Act as mentioned above. We start with the industrial applicability. As the first requirement for obtaining patent rights, an invention should have industrial applicability. Industrial applicability here means that such invention can be applied in the business of companies in the industrial sector in a broad sense, including not only the manufacturing industry but also mining, agriculture, fisheries, transportation, financial business, telecommunications, and other industries. Firstly, it is sufficient for an invention to be deemed to have industrial applicability if there is simply a possibility that said invention can be applicable to the industry in the near future, and it is not required to be actually utilized in the industry at the moment. Thus, an invention that has not yet been commercialized may be recognized to have industrial applicability. Next, industrial applicability does not signify that the economic benefit can be obtained. For example, the industrial applicability of an invention may be recognized even if such invention concerns a generator utilizing next generation energy that has enormous cost for its development, manufacturing, maintenance, etc. Novelty. As the second requirement for obtaining a patent right, an invention should have novelty. Novelty here means that the invention must objectively be something very new based on the date and time of which the application has been filed and the patent application with the patent office is being registered. Whether or not an invention has novelty is determined based on the filing time of its patent application, taking into account not only the date but also the time when the application documents were submitted to the patent office. To cite an example, Mr. X and Mr. Y have respectively completed the same invention. Alpha. In this case, if Mr. X files invention alpha at 1500 hours and Mr. Y makes a presentation of invention alpha at an academic society at 9 a.m. on the same day, Mr. X cannot obtain patent rights because invention alpha has already lost its novelty by 1500 on the same day. The Patent Act stipulates that the patent rights of the following 4 types of inventions cannot be obtained due to lack of novelty. In other words, inventions that do not correspond to the 4 types of process of novelty. The first type is inventions that are publicly known. Publicly known inventions here means that such inventions which are known to unspecified people as inventions that are not secret. For example, if invention A of Mr. X become known to Mr. Y, who is not bound by confidentiality, obligations to Mr. X invention, here A loses its novelty. The second type is inventions that are publicly worked, publicly used inventions. For example, if invention A of Mr. X has already been commercially available by Mr. Y, who is not bound by confidentiality, obligation to Mr. X invention A has lost its novelty. The third type is inventions that have appeared in distributed publications. Inventions publicly known in publications. Publication here means various type of transmitted media, such as the newspapers, magazines, books, microfilms, and patented gazettes. And distributed means that such publications are placed in a state in which unspecified people can read them. For example, if a magazine A in which invention of alpha of Mr. X appears has been placed in a library in a state in which anyone can read it, invention alpha loses its novelty even though no one has actually read magazine A yet. The fourth type is inventions that have been made available to the public through telecommunications. Inventions publicly known through the internet. Telecommunication here means connections through which interactive communication is possible, such as the internet, and available to the public means that an invention is placed in a state in which the public can access its disclosed information. For example, if invention alpha of Mr. X is posted on a website, invention alpha loses its novelty, even though no one has actually accessed the said website yet. Inventive steps. As the third requirement for obtaining a patent right, an invention should have an inventive step. Inventive step here means difficulty due to which even an engineer in the field to which the invention pertains cannot easily complete such invention, considering the technology level at the time of filing the patent application. As with novelty mentioned above, whether or not the invention claimed in a patent application has an inventive step is determined based on the filing time of its patent application as well as the fact which occurred previously in India and abroad. Whether or not an invention has an inventive step is determined with a reference to a person having ordinary skill in the technical field to which the invention pertains. That means those in that particular art. That is, it is determined based on whether or not those in the art form could easily have arrived at the invention claimed in the patent application based on the above mentioned inventions without novelty and by performing at their usual creative ability. For example, if an engineer of a clothing can easily conceive a reversible garment alpha based on garment B that has been supplied conventionally, reversible garment alpha does not have an inventive step. On the contrary, even if an engineer of clothing cannot easily conceive of reversible garment alpha based on conventional garment B, reversible garment alpha is deemed to have an inventive step. Exception to loss of novelty. Exceptions to loss of novelty means a system in which an invention is considered not to have lost the above mentioned novelty under certain conditions, even if the said invention has lost its novelty. As will be described later, the Utility Model Act and the Design Act have the similar system of exception to loss of novelty as well. As for the first condition, an invention that has lost its novelty against the will of the person having the right to obtain a patent is deemed not to have lost its novelty. For example, a case in which an invention has been stolen and disclosed by an industrial spy. Next, an invention that has lost its novelty by an act of the person having the right to obtain a patent for himself or herself is deemed not to have lost its novelty either. For example, a case in which the inventor, him or herself, has made a presentation of his or her own invention at an academic society or in publications. Let's come to the conclusion. Hereby, we have understood the various ways and means by which we can protect our intellectual property and original work. The law enables and empowers us to preserve, utilize, and secure our original work and thus ensures great work is given its due credit. And now it's time for a quick recap. Today we discussed the meaning, need, and significance of Intellectual Property Act. We also learned about the various guidelines of copyright, patents, and trademarks. Later, we discussed the characteristics and type of intellectual property, along with the exceptions to the rule for the same. And that is all we have for you today. Hope you enjoyed the session and learnt about the importance of Intellectual Property Act. We shall soon return with another interesting episode on media ethics. Until then, farewell and namaskar.